Szia, Márti!
Szia, Zsuzsa!
Csak mi ketten?
Jó tanuló, jó sportoló.
Már megint. Várjál, volt szó ma a kis konferenciáról. Novák Katalin, mint védnök fel lesz kérve.
Igen, mondta.
Jó. Ennyi hangzott el, mert itt a végén nagyon be kellett gyorsulni. Ennyi.
Szuper.
Jó, te mit fogsz mondani? Én összedobtam ilyen anyagokat így. Hát.
Én is valamit összedobtam.
Én valamit összedobtam. De már a második részből.
Jó.
Úgyhogy...
Én rá fogok kanyarodni majd az
jó,
elsőről a másodikra. Hát nem ez lesz életem előadása, de...
Hát na jó, hát ezt mindannyian tudjuk. Én éjszaka nem aludtam. Marha kemény nap volt a mai, úgyhogy kész, tehát ezt nem is tudom. Csak a kávé tart életben szerintem.
Megértem. Te otthon vagy már?
Aha. Te bent vagy? Igen. Hát nálunk a minisztériumban semmit nem lehet csinálni. Tehát ott maximum telefonról tudok bármit.
Aha.
Tehát ott mit nem
is nem engedik. Semmit
nem enged. De az OBH-val nem tudtunk egyeztetni egy nyomorult Skype for Business platformon. Nagyon durva volt. Hát, na remélem minden rendben lesz.
Én is.
Ugye te fogsz írni majd, mert én csak egy nagyon kicsit az elején érintem, egy fél oldalban, hogy azt már pont megcsináltam, ezt a gondnokság alá helyezés kérdését.
Igen.
Figyelj csak, Márti, amikor így olvasom a cuccot, tehát megnyitom, akkor te ugyanúgy láttok engem kamerával, nem?
Igen.
Hello, everyone.
Hello, Wojtek. Hello.
Hello, Zsuza. Hello, Marta. So it is 6 p.m. We will start, okay?
Okay.
So I am opening our scientific seminar. Today it will be of a working nature. I would like to ask everyone to briefly present VSNs to the research topic and the progress of work in few words, no more than 10 minutes, okay?
Okay.
Then there is time for possible question and discussion. So to begin with, please, Professor Marta Osuchowska, give us your presentation, remarks, statements. Are you ready?
Yes, I'm ready.
Yes, please.
So, good afternoon. I'm delighted that we can meet again this month. Today I want to introduce the area of my second research topic. In the second area of research I am undertaking as a part of our project is working in retirement. This month I start my research work on the second topic. So far I have been able to collect material in the form of legal acts. I have also made an analysis of them. The aim of the study is to provide a broad analysis of the legal arrangement with regard of the possibilities to active employment for retired seniors. I want to answer the questions. Can a pensioner in Poland take up employment and under what conditions? And how should additional income be accounted for and what limits apply? The main area of research will be the legal acts that allow retiring in Poland. In addition, social research showing the area of the issue also will be analyzed. The research will be served to verify new legal regulations introduced in Poland. Moreover, as a compilation of legal information in this area, it can serve informative purpose for those who wish to undertake the kind of activity. There are various reasons why pensioners become economically active. Most often is a desire to earn an additional pension. Therefore, it is necessary to analyze both of the legal basis for such activity and the amount with constitutes an acceptable limit. The research will separate different professional groups, including uniformed service, teachers, etc. The project will also take into account other social benefits as a comparative legal element. In particular, the pension, which is many situations, is also a benefit received by seniors. At the beginning of the research, there was again the problem of defining the subject. For example, in defining the difference between a senior citizen and a pensioner, about the age, because we are talking about the age of the senior citizen, we are talking about the 60, 70, and the pensioners are different in every country. It's about 60, 62, 65. As a general rule, seniors are pensioners. Although different retirement age must be taken into account. For example, for the group of soldiers or teachers or the other groups. Not only from country to country, but also for the different professional groups. My subject is only about the Polish legal acts, but I want also to research other countries in the European Union. Just only for the basic stage. I believe that the topic is important for the point of the view of active senior citizens. Research shows that the main obstacle to taking up activities such as culture is lack of money. However, the extra money is mainly spent on health improvements and medicines in Poland. In my research, I will also analyze sociological and statistical studies from the point of the view of senior citizens, activity in the labor market. It will give me a broad view of the topic I have undertaken. So, thank you very much for today's meeting. For today, I've got only this topic, the basis topic. I have started my second topic. So for this month, I only collect the legal act and made an analysis of them. I think that the other month I will take the other subject and will take more about this subject. So thank you.
Thank you very much, Professor Marta, for your speech. The next speaker is Professor Konrad Walczuk. I'm glad to see you, Konrad. Could you present your presentation?
Of course. Hello, Wojtek. Hello, viewers.
Hello.
It's nice to see you.
Hello.
The first, sorry for my English. Last month I work mainly with different Slavic languages, so I have really problem to switch the group of languages to English or German. Of course, for Hungarian too. As I wrote, I understand only super in Magyar.
It's okay. Your English is perfect.
You know,
Really?
you know, in Polish we say pierwsze koty za płoty. So maybe some days it will be better. Okay, let me first introduce a few sentences in the subject of my research, and then I will tell you in really 2 sentences about what I'm currently doing. Okay?
Yeah.
Okay. The elderly are a group that, due to natural conditions, has special rights and are subject to specific, of course, in a particularly limited way, obligations, usually having general freedoms, which I have shown in materials recently prepared for publication. Regulations of constitutional nature will be assessed, but most of all those contained in special acts and their executive acts related to extraordinary states. It means martial law, state of emergency, state of natural disaster. And the other way, epidemic and crisis situation. It means it's with crisis management. It's related to crisis management. During the classes conducted for officers of the Polish armed forces, voices appeared pointing to particular difficulties related to ensuring the safety of elderly people during extraordinary states and crisis situations. It's on the one hand. And on the other hand, the necessity of operating within the framework indicated by formal regulations. Based on the previous findings of a general nature, the study may help to dispel at least some theoretical doubts and then effect of efficient application of legal regulations in practice, both by uninformed services and other representative of public administration. It means state and local administration. And currently, I ordered to implement the planned activities. I'm collecting the relevant literature and jurisprudence. And of course, I used the internet for this because so far there are not too many printed materials about the latest situation. For example, related to the situation on the eastern border of Poland. As you know, we call it hybrid war. So thank you for your attention. Thank you.
Thank you very much, Professor Konrad. It was good. Everything was clear. Thank you very much. I'm asking for a presentation by Professor Zsuza Wopera, okay?
Okay.
Yes, please.
Okay. It would be a little bit longer.
Okay, no problem.
No problem, but not more than 10 minutes.
Yes.
100%, 100%. So, dear colleagues,
Professor, nobody is perfect.
Okay. Dear colleagues, dear team members, in the second part of my research, I undertook to examine the protection of elderly in current Hungarian civil law and civil procedure law. I would like to emphasize that I am still at the very, very beginning of the second phase of my research. This part of the research, I will examine the legal framework of procedural protection covering the following questions: the supported decision-making in civil procedure, and the right of contact of the elderly relatives, for example, grandparent, under the Act on Civil Code, procedures initiated to ensure a right of contact of elderly relatives. And at the beginning of the research, I would like to give some proposal, the Lega Ferenda proposal for an effective legal representation of elderly. It could be the lawyer for the elderly, but it's just an idea. So let me allow some introductory remarks about the Hungarian legal system. Hungarian civil law recognizes several procedural options for the protection of the rights of persons whose capacity for conducting their affairs has decreased. One of these options is the placement under guardianship. Two forms of guardianship are regulated by the Hungarian Civil Code: guardianship partially limiting capacity to act, this is the partial guardianship, and guardianship fully limiting capacity to act, this is the plenary guardianship. In the judgment of partial limitation of the capacity to act, the court shall specify those categories of affairs of a personal or property nature in which the capacity to act is to be limited. Placement under guardianship entails the consequence that the legal declarations of the person placed under guardianship require the consent of the guardian, who is appointed by the guardianship authority for the person placed under guardianship. The substantive legal sources of guardianship are contained in the Civil Code, while the procedural rules are contained in the Code of Civil Procedure. So this presentation doesn't analyze the rules of guardianship in detail because it belongs to the research area of another researcher. It is the topic of Marta. So at first, I would like to speak about the supported decision making as an alternative of the guardianship. In accordance with the UN Convention on the Rights of Persons with Disabilities, the CRPD, when the Civil Code the Hungarian Civil Code entered into force in 2014, the aim was to introduce a procedure to help a person in need of support, which doesn't affect the person's capacity to act. The supported decision-making is a worldwide alternative to guardianship. Instead of having a guardian make a decision for the person with the disability, supported decision-making allows the person with the disability to make his or her own decisions. Supported decision-making came into the forefront of attention with the adoption of the CRPD. According to the Article 12 of the CRPD, said that states parties shall recognize that persons with disabilities enjoy legal capacity on equal basis with others. There are almost 60,000 adults under guardianship in Hungary, but their number is expected to increase significantly in the future due to the aging of the population. The number of individuals with intellectual or developmental disabilities under guardianship is expected to increase over the next few decades. The data suggests that by 2030, there will be more than 100,000 people with intellectual disabilities in Hungary who are at the risk of guardianship. This is 1% of the whole population of Hungary. According to Civil Code, the guardianship authority shall, at the adult's request and in order to avoid limiting his capacity to act, appoint a supporter for the adult who, due to not being entirely of sound mind, needs help in administering some of his affairs or making his decision. Besides the regulation of Civil Code, a separate act introduced the supported decision-making procedure in Hungarian law. Supported decision-making provides assistance to the individual circumstances of the affected person is managing their affairs and making decisions if they need due their reduced capacity. The supporter provides assistance in making the legal declarations and can therefore also be present in official proceedings involving the supporter. The fundamental difference between supported decision-making and guardianship is that the consent of the person concerned is not required to be placed under guardianship. It's a big problem. And the supporter can only be appointed at the request or with the consent of the person concerned. The role of the supporter in an action, according to the Code of Civil Procedure. If a supporter is appointed for a party by the guardianship authority, the supporter may be present along with the party at all procedure acts during the action, including hearings held with the exclusion of the public, but his absence shall not be an obstacle to carrying out a procedural act or continuing the act. It's very important that the supporter may not make a juridical act in the place of the party supported by him. Although the new civil code adopted in 2013 contains a partial reform of the Hungary's mental capacity legislation, the new regulation fails to meet the requirements of Article 12 of the CRPD. General problems can be identified by the special literature. The Civil Code introduces the possibility of supported decision-making, but it doesn't abolish the substitute decision-making. The Act preserves the models of the plenary and partial guardianship as instruments of substitute decision-making. A further point of concern is that the regulation of the Civil Code doesn't sufficiently recognize the situation-specific character of mental capacity. The regulation of supported decision-making of the Civil Code is very rudimentary compared to the detailed regulation of guardianship. Although there is a separate act on supported decision-making, the regulation remains quite superficial, perhaps because supported decision-making was always intended to be merely secondary or supplementary to guardianship. So the second part of the research is to analyze the right of the contact of the elderly relatives. The Hungarian Civil Code basically regulates the right of contact with the child between his or her parent who are living separately. The Civil Code also entitled other relatives to contact with the child for persons other than the parents, including the grandparents. According to the article, the grandparents, the sibling, and if the parent and the grandparent are not alive or are permanently prevented from having contact with the child or do not exercise the right of contact of their own fault, the sibling or parents of the child parent shall also be entitled to have contact with the child. Among elderly relatives, the Civil Code designated the grandparents' right of contact with the child. This means that, for example, such a right of the great-grandparent cannot be enforced based on the Civil Code. It could be a problem in the case law. According to the judicial practice, the right to contact between a child and the grandparent is fundamental constitutional right, a child rights, or a basic human rights, but not an independent personality rights. In the Hungarian legal system, both the court and the guardianship authority have jurisdiction over the issue of contact with the child. The court has jurisdiction over the settlement of contact if there is a divorce case or a parental custody case pending. Given that such an action cannot take place between the grandparent and the parents, always the guardianship authority decides on the issue of the grandparental contact with the child. The question of contact with the grandparents arises most often and most acutely with the parent dies and the other parent doesn't allow contact with the deceased parent's relatives. This typically arises when the parents have already divorced and their relationship is full of conflicts. It makes the situation even more difficult if the surviving parent finds a new partner or gets married, because in this case, the contact with the deceased parent relative is even more in the background, since the child will have a new family. So I'm currently, in this point, I'm currently staying here, working on the second part of the research. So I cannot give a presentation more because I am in the very beginning of my second part of research. But thank you for your very kind attention.
Thank you, Professor Zsuza. You fit in your time perfectly. Thank you very much. Now we listen to a presentation of Professor Marta Benyusz. Marta, could you present us some remarks of your topic?
Yes, thank you very much. Good afternoon, everyone. It's a delight to be again with you in this Monday evening. So actually, I will not strictly talk about my new topic because it's, as you all said, only at the beginning, but I will talk about an overlap that is between my first article and my second article, which is the Convention on the Rights of Persons with Disability and the protection offered by this international law instrument. So last time I introduced the international legal human rights framework. I covered the definition of elderly and the nature of elderly rights as regards human rights protection. I listed the pros and cons as regards the adoption of a separate legal instrument for protection, and I concluded that the current human rights protection is not sufficient, and actually I highlighted the normative, the monitoring, and the implementation gaps that occur in this legal framework. So the next step is the Convention on the Rights of Persons with Disability, which currently offers the most useful protection, although it does not it was not adopted for the purpose of protecting the group of elderly, but for the purpose to protect persons with disability. So it is very similar as regards disabled persons as the CEDAW is in connection with women, or the CRC regarding children. It marked a caring model, a shift from a caring model to a rights-based model. The principles of the CRPD are also very tangible and also can be used and I will further list why is it so important and why this instrument is the one that can finally and at last be called when searching for the international law protection of elderly. So these principles are, of course, the respect for human dignity, the non-discrimination, full participation, all inclusion in society, equality, and accessibility. Obviously, not all older persons have disabilities, and as I mentioned, the CRPD does not single out elderly for special protection, but if we make a textual research, we find some explicit reference to older people, like for instance, Article 8 of the Convention calls for combating age-specific stereotypes. The preamble excludes the discrimination on the basis of ages. On the basis of age, Article 23, in connection with respect for home and family life, underlines the right to age-appropriate information. Article 25 on the right to health, in connection with the state obligation to provide health services, explicitly mentions the group of older people, as well as Article 28 on the adequate standard of living and social protection in a context that their access of their services to be ensured. So to conclude, as regards the explicit reference, it is obvious that under the CRC there is no specific protection, but it is also important not only to search for the explicit references, but also to see the implicit ones. And if we look at Article 1 of the CRPD, which defines disability and says that persons with disabilities include those who have long-term physical, mental, intellectual, and sensory impairments, which in interaction with various barriers may hinder their full and effective participation in society on an equal basis with others. The question what arises here and what needs to be posed immediately is when is a person old and when is a person disabled? And if we look at this question from a historical point of view, a person was regarded elderly when their disability decreased to a point at which they were regarded as crippled or infirm. During this time, the definition of old age and disability were largely conflated, but for contemporary times, medical science has clearly altered this position and now distinguishes old age and disability very clearly. Nevertheless, the CRPD's definition includes those disabilities which are as a result of aging and thus offers much support to those elderly who are disadvantaged by policies associated with medical model. However, the CRPD offers little support to older persons who are disadvantaged by structural discrimination on the basis of ages. So it does not really protect the discrimination that stems from ageism. So the general conclusion can be said that the CRPD, yes, it offers a kind of human rights protection to the elderly, but only those who can fit in the definition of disabled elderly, but not to those who just become like a natural life circle, become older and become discriminated just because of this state of age. So the second part of my research will actually come from CRPD and especially from Article 12 of the CRPD, and will examine the existing Hungarian legal background of protection with a special regard to the implementation of this article. And the paper will cover the questions of the regulation of legal capacity. It is seen that while during the monitoring process of the CRPD, the committee that does this monitoring and screens the legislation usually makes the remark that older people and older people with disability should have, regardless of their disabilities, a full legal capacity. So I will actually cover this topic as well. I will cover the regulation of guardianship and the procedures initiated to ensure guardianship under the Civil Procedure Code, like Preliminary Judicial Act. And I will make the lega ferenda proposals on ensuring the full legal recognition of elderly persons, especially elderly persons with disability. Thank you very much.
Thank you, Professor Marta. According to the agenda of our open seminar, it's time for presentation by Professor Erika Varadi-Csema, but I don't see her. Do you know what happened with her?
I don't know anything about her.
I'm sorry, I don't know.
No.
She maybe forgot this.
Maybe forgot it.
Yeah.
I hope that everything is okay with her.
I can call her. I will ask.
You try to call her.
Try to contact.
Yes, if you can. In this time, I present my topic. So the subject of the second of my study is the maintenance and non-maintenance obligation of family members towards an elderly. The topic concerns a very important issue of mutual relations between the elderly and their children and grandchildren. It is obvious that family roles change over time, and as a consequence, the elderly who provided care for their children often need such care themselves after reaching the old age. By caring, I understand both spiritual support and material help. This matter is somewhat beyond the attention of our legislator. Provision of care, help, and support is based on the norms of social coexistence. More precisely, it is a consequence of the emotional ties between children and their parents. However, this usual approach to the subject of elderly care is not always sufficient. It is not uncommon for elderly people to remain unattended because their children are abroad, live far away from their parents. They have too much of their own responsibilities. They do not understand the needs of the elderly, or simply they leave them to themselves. A number of questions arise as to whether the obligation to provide care for the elderly must always be borne by the state or local communities. Can the cost of such care be borne by relatives of the elderly? Is it possible to force the fulfillment of this obligation, especially in the sphere of spiritual support? It means emotional care. Are the children of parents using institutional assistance obliged to contribute to the cost of providing it? How can and should children support their older parents? Are there any legal provisions that would oblige the children and grandchildren of older people to provide them with care? Can such care be legally enforced before the court on the basis of the provisions on the maintenance obligation? I am also at the very beginning of studying this issue. I collect scientific materials, analyze normative acts and jurisprudence, browse the literature on the internet, and read some post-it on the internet. I am also observing media reports of similar cases. So this is just the beginning of work on this problem, but I hope I will manage with it. Thank you very much for your attention. Did you phone to Professor Erika?
Yes, I succeeded. And she tried to join to the seminar.
Mm-hmm.
She said.
Yeah.
Yeah. I told her that she is the next. She said, okay. But
so maybe we pass to the next step of our agenda of the agenda of our scientific seminar. The second step is discussion. So I open the discussion. Is there anyone who would like to ask a question for one of member of our team? This is a good moment when everyone can ask the question, or at least present your own point of view about our presentations. I can't see any question. So the next part is organizational matters. In this part, I kindly remind all of you of two issues. Firstly, about the obligation to submit monthly reports by the 5th of each month, not later, by the 5th of each month. Secondly,